please the court, my name is Brannon, and I represent Miguel Diaz-Rodriguez. Mr. Diaz has appealed the decision of the district court for the 18th Judicial District, Sedgwick County. Mr. Diaz is here to ask this court to reverse the district court's decision to grant summary judgment for the defendant, Learjet. Mr. Diaz was instructed by his boss to purchase a Model 60 Learjet airplane.
So we're familiar with the record.
Yes, Your Honor. The district court should not have granted summary judgment to Learjet. The district court erred when it failed to consider the liquidated damages clause in the contract in light of Kansas Statute 84-2718. And this error was not harmless. First, I'd like to focus on the district court's error itself. Now, the error was the court's failure to evaluate the liquidated damages clause in light of 84-2718. That is a UCC provision, and the UCC governs sales of goods, and therefore it governs the contract between Diaz and Learjet. And that statute says that damages can be liquidated only in an amount that is reasonable in light of the anticipated or actual harm caused by the breach, difficulties of proof of loss, and the inconvenience or non-feasibility of otherwise obtaining an adequate remedy.
Counsel, didn't the judge's opinion actually talk a lot about the infeasibility of calculating damages?
The judge did address that, but the district court did not address the first prong of that test, which was the actual or anticipated damages. And that's really what I like to focus on, because that's something that's required by the statute. The judge said that the test was whether the liquidated damages clause was out of proportion to the contract. And the court then concluded that it was not out of proportion. The district court did not consider the reasonableness of the liquidated damages in light of the anticipated or actual harm caused by Diaz's breach. Damages are supposed to put the seller in the position it would have been in had the contract been performed. And that was not the approach that the district court took in this case. Now, whether the liquidated damages are out of proportion to the contract really doesn't tell us very much. That's not the same as considering the anticipated or actual damages that are caused by the breach.
But counsel, isn't that a very common way of looking at liquidated damage clauses? Just simply look at the size of the contract and look at the size of the liquidated damages clause, and if it seems reasonable, just uphold it?
That might be a common way of looking at many contracts, but that approach shouldn't apply in this particular case, because this is a sale of goods and it's governed by the UCC. And this court in Vassay versus Murray addressed that, where the district court made a similar error evaluating past profits, and this court said, no, you need to look at the actual damages. So that's what the statute requires. And the out of proportion standard used by the district court is particularly problematic. It's not really clear what that means. Somebody could look at the number 250,000 and compare that to the number 8,500,000, which was the total price of the airplane, and then conclude that that's not out of proportion. That doesn't mean that 250,000 represents the actual or anticipated damages incurred by Learjet.
Counsel, I have a question about the remedy that you're asking for. You say you want us to overturn the decision. Do you want us to send it back down to the lower court to make another judgment with the appropriate standard?
Yes.
Okay.
Yes, I'm asking this court to remand the case so that the district court can evaluate the liquidated damages clause in light of 84.2718.
But liquidated damages clause, whether or not that's reasonable is a question of law, right? Can't this court just make a decision on its own?
Well, before the statute requires a determination of the actual or anticipated damages. That's a question of fact. Damages are a question of fact. So the district court needs to make that determination first. Then the court could consider whether that's reasonable, apply the statute, and then this court will be in a position to review the district court's determination of reasonableness. And it is unclear where the district court's standard came from. It may have come from a non-UCC case. But regardless, it was incorrect. Now, I want to stress that the district court's error was not harmless error. It was prejudicial to Diaz, and it affected the district court's decision. The district court would not have granted summary judgment to Learjet if it had followed the proper test. Summary judgment can only be granted when there is no genuine issue of material fact.
Counsel, why is it that this court wouldn't be able to decide as a matter of law that the liquidated damages sum was reasonable in light of anticipated damages, based on the record before the court at this time?
Because anticipated damages involves a question of fact, and the district court has to decide that, has to take evidence, testimony, have a trial on the damages to determine that.
But isn't that actual damages, not anticipated damages?
They're both questions of fact. Anticipated damages would be a question of fact as well. And it would, and this, the anticipated damages and actual damages were questions of fact, material fact, that were disputed. Learjet and Diaz disagreed over that. The district court's findings of fact do not show an agreement between Diaz and Learjet over the actual or anticipated damages. The court even said there's no evidence of a nexus between the $250,000 and the anticipated or actual damages. And so the district court could not have granted summary judgment to Learjet if it had been following Kansas statute 84.2718. Diaz, therefore, asks this court to reverse the district court and remand the case for consideration of the liquidated damages clause in light of 84,2,718.